morning, everyone. It is my pleasure to reconvene the 26th meeting of the Joint Select Committee on Human Rights, Equality and Diversity. This public hearing is being broadcast on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I'd like to welcome the officials present with us today from the Ministry of Labour and Small Enterprise Development, the Office of the Prime Minister, the Equal Opportunity Commission, the Equal Opportunity Tribunal, the Employers Consultative Association, Working Women for Social Progress, the Network of NGOs of Trinidad and Tobago for the Advancement of Women, and the Trinidad and Tobago Institute for Women in Leadership. My name is Dr. Leanne Gassidoli. I'm the chairman of this Joint Select Committee, and at this point I would like to invite the members of the committee who are here with us to introduce themselves, starting on my right.
Yes, good morning to all. Esmond Ford, member of this committee.
Good morning, Rushton Parry, member.
Good morning, Kazim Hussein, member.
Thank you so much. I would like to now invite the officials who are present with us to introduce themselves, and we can start from my left with the Permanent Secretary of the Office of the Prime Minister.
Good morning, Jackie Johnson, Permanent Secretary, Office of the Prime Minister, Gender and Child Affairs.
Lynette Sibaran-Sweet, Chairman, Equal Opportunity Commission.
Good morning, Narendra Lalbihari, Registrar, Equal Opportunity Tribunal.
Good morning, Madam Chairman and members of the committee. Sangeeta Bundu, Senior Legal Officer, the Ministry of Labour and Small Enterprise Development.
Good morning, I'm Stephanie Fingal, Chief Executive Officer of the Employers Consultative Association.
Morning, everyone. My name is Jackie Burgess, and I represent today the Network of NGOs and Working Women.
Good morning. I'm Hazel Brown. I'm the Director of the Trinidad and Tobago Institute for Women in Leadership.
Good morning. My name is Sabina Gomez, and I'm the Chief Labor Relations Officer.
Okay, thank you so much to all the officials who are here. The purpose of today's meeting is to continue discussions on sexual harassment in the workplace. Approximately 1 month ago, the Joint Select Committee on Human Rights, Equality and Diversity met to examine sexual harassment in the workplace. We explored many issues, including the underreporting of sexual harassment and possible reasons for same, as well as the definition and forms of sexual harassment. Today, we continue this discussion with a civil society enhanced panel of officials joining the ministries and agencies which were present during the first leg of this inquiry. Our purpose today is to add to the body of information gleaned on the last occasion, specifically referencing the third objective of the inquiry, which reads, to examine and make recommendations on A, current management procedures and mechanisms to seek redress as a victim of sexual harassment in the workplace, and B, current legislation and policies, local, regional, and international, to treat with victims of sexual harassment in the workplaces of Trinidad and Tobago. I'd like to acknowledge that we did receive written submissions from 16 entities. WINAD, with 8 NGOs contributing to this submission, the Network of NGOs of Trinidad and Tobago for the Advancement of Women, the CEDAW Committee of Trinidad and Tobago, the Equal Opportunity Tribunal, the Ministry of Labour and Small Enterprise Development, inclusive of the National Workplace Policy, the Office of the Prime Minister, the Equal Opportunities Commission, the Employers Consultative Association, the International Labour Organization, the Industrial Court of Trinidad and Tobago, the Trinidad and Tobago Police Service, the United Nations, UNICEF, the Human Rights Clinic of the Hugh Wooding Law School, the Faculty of Law, UE, and the Office of the Ombudsman of Trinidad and Tobago. At this point, our listeners and viewers can send questions related to today's topic via email at parl101@ttparliament.org, or on Facebook at TT Parliament, or on Twitter at TT Parliament. At this time, I would like to invite brief opening remarks from the entities that did not appear at our first public hearing. And so those would be the Equal Opportunity Tribunal, the Working Women for Social Progress, and the Network of NGOs of Trinidad and Tobago for the Advancement of Women. I think we have Winard joining us. She's not here. And Mrs. Hazel Brown, Director of the Trinidad and Tobago Institute for Women in Leadership. So I'll call the names that we have here as we invite comments from you. So let's start with the Equal Opportunity Tribunal.
Thank you, Madam Chair. The Equal Opportunity Tribunal essentially is a superior court of record that operates under the Equal Opportunity Act. We are mandated to hear matters of discrimination that has been sent to us by the Equal Opportunity Commission. As indicated in our submission, we do have certain matters that has come before the court relating to sexual harassment, and these are matters that we would need to make a pronouncement on in the near future. We are really here to provide any assistance we could in relation to the interpretation of our current legislation, and any assistance in terms of how that relates to sexual harassment. Our submission included other international agencies and legislation at an international level pertaining to sexual harassment, and essentially outlining some of the deficiencies in Trinidad and Tobago as it relates to sexual harassment, and maybe where we can be in terms of legislation for sexual harassment. Thank you.
Thank you so much. I'd like to invite now Mrs. Burgess.
Okay. The Network of NGOs just last year held a symposium, a dialogue really, where the topic was sexual harassment. Working Women as well has been involved in raising awareness on sexual harassment, and in January of this year we had our anniversary lecture dedicated to sexual harassment. We have always advocated for special legislation for sexual harassment. We are now leaning towards supporting the EOC amendments. Essentially, what we see our role as really raising awareness on the issue and how people can treat with it.
Thank you. Ms. Farade Motota of Benard.
Thank you very much, Madam Chair. WINAD exists to advance the rights of women and girls through thought leadership, mentoring, quality service delivery, and stakeholder engagement. A core value for us is collaboration, and our internal policy on stakeholder engagement informs our agenda for expanding visibility and participation of NGOs in key decision-making processes within the state sector. Naturally, when WINAD was invited to make a submission to this committee on the issue of sexual harassment, we extended the invitation to other civil society partners in an effort to have their voices and the voices of others also recorded in the work of this committee. Some of the organizations we invited to collaborate on the written statement we submitted were also invited to make submissions to this committee, but some were not. And for the benefit of the listening and viewing public, I want to list the names of the organizations that contributed to the statement. And they are AFET, the Banking, Insurance and General Workers Union, CAISO, the CEDAW Committee of Trinidad and Tobago, the Family Planning Association of Trinidad and Tobago, Fire Circle, and Womantra. I also wish to recognize Mr. Sean Morris, who is WINAD's other representative here this morning. Whilst acknowledging the definition of sexual harassment advanced by the committee, for us, sexual harassment is not solely a workplace issue. It spans multiple settings, not all of them workplaces, and does not always occur between workers. It also occurs in cyberspace. It occurs also between beneficiaries or service providers and institutional stakeholders, for example, between educators and students, healthcare workers and patients, police officers and victims of crime, religious leaders and their members, etc. Sexual harassment includes conduct that creates a hostile or humiliating environment through offensive or taunting references to sex and to gender. This is the most prevalent form of sexual harassment reported by the LGBT+ community. For us, all sexual harassment must be prohibited, whether it takes place within the organization's premises or outside, including at social events, business trips, training sessions, or conferences sponsored by the company or the organization. We understand the challenges which underreporting causes for policy development and legislation, and wish to suggest that underreporting is largely a consequence of the nature of sexual harassment, characterized by fear of victimization, retaliation, stigmatization, and gender stereotyping, which ascribe roles and levels of power to men and women. And finally, we are of the view that bystander training to empower onlookers to recognize and act when they witness sexual harassment, along with whistleblowing policy that ensures anonymity, can potentially increase reporting. Thank you, Madam Chair.
Thank you so much. Mrs. Hazel Brown.
Thank you very much, Madam Chairman. We just want to add that in considering issues of public policy, it's important for us to be clear about the context in which these discussions and decision-making takes place. And the context in which we want to suggest that sexual harassment should take place is a human rights context in which sexual harassment, which is considered to be a question of power relations, is addressed in the context of democratic rights and freedoms of the people who are affected. Hence the reason we've pursued this matter as a human rights issue in the context of how public policy is developed. Thank you.
Thank you so much. At this time, we are going to begin the questioning. I want to remind both our officials as well as the committee members to direct your questions and concerns through the chair as we begin. So let me start with the Ministry of Labour. As we said, the context. We have recently developed and given to the public the National Policy on Sexual Harassment. Has this been laid in Parliament?
Madam Chairman, yes, the policy would have been laid in Parliament by the Honourable Minister in the month of March on International Women's Day. It would have been laid in Parliament.
I just, up to now. All right. I just want to suggest that maybe we have to check the records to ensure that that was actually, document was actually laid.
Madam Chairman, as far as the Minister made a statement in Parliament, so we will have to double check and ensure that the document itself was laid in Parliament.
Yes.
Thank you for the guidance.
Yeah. Okay. So that document is now, it's public, it's on the website, and so on. It's available for the country to look at. What I want to ask is, what exactly is expected from employers, business places, from the public? What exactly is the expected outcome of having this national policy on sexual harassment? Is it just a document that is there for you to look at and to see? What goes behind this?
Okay. Thank you for the opportunity, Madam Chairman. The policy is, you're correct, on the ministry's website, www.molsed.gov.tt, for the benefit of the listening public, under the resources tab. The first thing we would like everyone to do is to download a copy of the policy from the website and read it, because it not only speaks to employers and employer organizations, but it also speaks to workers. The policy was developed on the premise of a rights and responsibilities framework within the workplace, so it spells out both for all the parties at the workplace. Some key elements of the policy is that we have included in the policy tools for use. For instance, we have prepared a draft complaints procedure and guidelines, a draft complaints form. So for organizations that do not already have a sexual harassment policy at the workplace, and for workers who are not familiar with one, they can not only use the policy, but those guidelines at the workplace in order to implement. Now, with respect to, those are the immediate aims. The ministry proposes that the policy would be not only subject to implementation through public awareness campaigns and through education at various levels. We would have done a media blitz with radio and TV appearances to draw attention to the policy over the last couple of weeks. What we also aim to have implemented in the long term is legislation. We are aware that currently the legislative framework will allow for redress of sexual harassment complaints through different fora, but we want to create specific legislation to bring implementation to this policy to the fore.
So for the benefit of the public who is listening, they can visit the website, they can download the policy itself and read that. Now, having read it, they may be more aware of what their rights are, what exactly is sexual harassment. They may be able to define behaviors that have been advanced towards them, and so that maybe fall into the category of sexual harassment. Is there any impetus at this point for employers to take on board the guidelines that are outlined in the policy to implement sexual harassment policies within and procedures within their workplaces? Because we understand very clearly that though there may be some policies existing, in some cases the procedures are not clearly outlined, and therefore when people make the complaint, they end up hitting a brick wall because there's no actual structure for their complaint to be taken, investigated, and dealt with, and so on. So is there any impetus? What would prevent, or is there any punitive clause for someone not implementing the guidelines in the policy?
At this time, there is no punitive clause within the policy itself, but what I would like employers to be aware of, and employees, is that there are specific pieces of legislation that redress can be found under currently, notwithstanding that this policy does not have that. And I would like my colleague, Ms. Gomez, the Chief Labor Relations Officer, she can go into a little further detail as to the specifics at the Ministry's Conciliation Unit under the Trade Dispute Procedure.
Good morning, Madam Chair and members and the listening public. Currently, what exists now, we have had so far coming in for the year, I think we have had about 5 cases of where workers would have gone to trade unions to seek representation in terms of issues arising out of sexual harassment claims. So they will come through the dispute procedure. It could be because the worker would have made claims and the worker would have been treated in a manner not according to good industrial relations principles and practice. So the worker would then seek redress through a trade union and have the trade union bring the matter to the ministry. So that is how, so it would not come under a direct case of sexual harassment. It would be issues arising out of sexual harassment. It could be a demotion. It could be constructive dismissal. So that is how the matter is brought to the ministry under the Industrial Relations Act.
So I just want to interrupt you to be very clear to make sure that the viewers understand. You are in a workplace. You believe you are being sexually harassed. You, the worker, do you have to go through a trade union? Suppose you are not a unionized worker. How are you to seek redress under the policy that is now been advanced by the Ministry of Labor? Because I'm hearing you speaking about it going through the union.
Yes.
What happens to the worker who is not unionized?
Well, that is for the worker who is not unionized. Currently, we have employers or companies where there are unions, or what we call recognized majority union, which is that you have the union have majority bargaining status within the organization. Those companies, and we went through a list in terms of how many organizations are unionized and they have sexual harassment policies. So there are sexual harassment policies that exist within unionized organization, and it could be found in the collective agreement that is negotiated between the employers and the trade unions. So there are coverage right now. It may need to be updated, but workers who belong to a unionized environment would have had some level of protection, whether it be under health. Some collective agreements have it under health and safety articles. Some have it under basic harassment clause, where sexual harassment is included. And we have examined some of those, and they need to be updated. So there are avenues for redress for unionized workers.
Through the union.
Right. But an ordinary worker on the street who suffer sexual harassment in the workplace, as it is right now, there is a policy and there is awareness. But in terms of legislative avenues for redress as it exists right now, it has to be through the Industrial Relations Act and Section 51(1).
So, if I remember correctly, when we met last month, just as we were leaving, we were looking at this point of a non-unionized worker being able to go into the Ministry of Labor Conciliation Unit to make a complaint and get guidance, yes?
Yes.
Can I get a little more on that? For the benefit of the members of the public who's listening, I want them to fully understand what this policy advances for them.
All right. In terms of an incident happening on the workplace and the worker doesn't know what to do, the worker is free to come into us and explain the situation. We'll take detailed notes and probably advise them, if they haven't done so, to write their employer, put it in documentation form so that it is properly documented with dates and times rather than just it being word of mouth. So that will initiate any process of investigation. So we advise them to go back, write what happened, whether there's an HR person in the organization that can take up the issue and have it properly investigated. If we find that in some instances where there was an instance that came to me recently where the worker would have made the claim and she started to be harassed by her female co-workers, male co-workers. They started to harass her and attack her for making the offense. Even when the investigation was being, this is the claim that she made us, when the investigation was being carried out, it was a unionized environment, but the union represented the male person, and she felt she was left alone without representation in the conduct. So you find that even within organizations right now, there's a bit of uncertainty And with sensitization and with the policy being implemented and having workshops, it will bring some level of, I don't know, clarity in terms of how an investigation is to be conducted and what is to happen, because this was an actual case that came into us.
Ms. Buru, you want to get into it? Bundu?
Yes. In addition, Madam Chairman, at page 22 of the policy, we would have outlined current avenues for redress under legislation. So I just want to draw some attention to, for instance, sexual harassment in the workplace or otherwise could also constitute a criminal sexual offense, and there's provision for that under the Sexual Offences Act. A complaint can also be filed under the Occupational Safety and Health Authority Act, where at Section 6, an employer has a general duty to employees to maintain and provide a safe working environment that is so far as is reasonably practicable without risks to health and safety. And there's also provisions where it is the grounds of discrimination under the Equal Opportunities Act for a claim to be made there. So notwithstanding there is no specific policy, there are other legislative avenues that could be used in addition.
Mr. Lalbihari?
Thank you, Madam Chair. I'd just like to, I'm having sight of this, and I'd just like to make some comments on it. We have to really be careful in terms of seeing that at this point, the Equal Opportunity Act seems to cover sexual harassment. I do not want to prejudge or have my words taken that we are prejudging any of the matters before the tribunal, because we do have matters relating to sexual harassment before the tribunal. But a perusal of the Equal Opportunity Act would show that essentially there's really no mention of the word sexual harassment, and we have to be careful in saying or seeking to interpret that the Equal Opportunity Act at this time, in its present way, can deal with issues of sexual harassment. Sexual harassment, it's a form of harassment. If you look at other legislations around the world, let's say we take, for instance, the UK. Their heading as it relates to harassment starts with Section 26 as it relates to harassment. And under that, you then have certain forms or types of harassment set out. So, for example, you have where one person harasses another, where it's meant to violate their dignity, etc. And then you have where a person is harassed because of a protected characteristic. You can have those characteristics as they're harassed because of their age, their disability, their gender reassignment, race, religion, belief, sex, or sexual orientation. My interpretation in terms of that we are using this word sexual harassment is really the activity in saying that this person is being harassed in a sexual way. So seeking sexual favors, you know, these quid pro quo kind of thing, where you want certain things from the person of a sexual nature. But we have to be careful at this time because the tribunal has yet to make a pronouncement on any issue as it relates to sexual harassment, so that we don't want a situation where it is being said that the Equal Opportunity Tribunal or the Equal Opportunity Act deals with sexual harassment, and you have persons coming forward. And then when or if a matter is dismissed on the basis that the Equal Opportunity Act, as far as, you know, if it happens that it does not deal with sexual harassment, you can then have persons wanting to complain and say, well, we were told that the Equal Opportunity Act and the Equal Opportunity Commission and the Equal Opportunity Tribunal, we were told that you all deal with sexual harassment, and then you are coming to say that you don't. So I'm just saying, I'm not saying that we have made a decision as yet, but I just want us to be careful in terms of how the interpretation comes about. Because this really is a policy document, and it is really meant as a document to build on. So, I just want us to be careful in that respect. Thank you.
Okay. And that's a very interesting point to note.
It might be appropriate as we are on that point, and as it were, we are sister organizations, both created under the Equal Opportunity Act. With your permission, it might be appropriate for me to make some remarks on Mr. Lal Bihari's submission.
Certainly.
Yes. The Equal Opportunity Commission itself is an independent body which is tasked with the responsibility of advocating for equality and non-discrimination in Trinidad and Tobago through advocacy research. And we also have a core mission of receiving complaints of discrimination on certain bases, on the basis of sex, religion, disability, marital status, origin, and so on. And we operate in 4 areas: in the area of employment, in the area of the provision of goods and services, in the provision of housing and training. And there is no doubt in my mind, and in the international jurisprudence, and in the international conventions to which Trinidad has signed on, that sexual harassment is a judicially recognized category of sex discrimination, both in the case law across the Commonwealth, in the United Kingdom. I cite the Porcelli case, which is a Scottish judgment, where there is a very, very clear-cut and persuasive pronouncement, which is of highly persuasive authority in our courts, including the court of which Mr. Lal Bihari is the registrar, that defines sexual harassment as a category of sex discrimination. Beyond that, we have all of the international conventions that we have signed. You have the UN Declaration on Women, 1993, I believe it is, which clearly defines sexual harassment as a category of sex discrimination. We have the Beijing Platform for Action. We have the Sustainable Development Goals. I mean, there's a plethora of international documents and instruments which have already recognized that sexual harassment is a category of sex discrimination. Indeed, in the Equal Opportunity Commission, we received our latest report is our report for the year 2017. Across the 6 categories of discrimination that we receive complaints in, we received about 20% of complaints in the area of sex discrimination. And 5 of those have included complaints of sexual harassment, and we are currently dealing with those. Now, the split in the work between the Equal Opportunity Tribunal and the Equal Opportunity Commission is that the Commission is tasked with the responsibility of receiving the complaint, investigating the complaint, and conciliating the complaint. And we have been doing that. If it is that the complainants and the respondent do not reach an agreement in a confidential conciliation, we at the Commission have the responsibility of initiating a case with the consent of the complainant in the tribunal. The tribunal is headed by Madam Justice Donna Prowell, and she has the status of a superior court of record, so that it is in that agency, if we do not conciliate, a person can get damages, injunctions, reinstatement, whatever remedy there is. I am not quite sure what is the appropriateness of a court entering into this discussion as to policy, which is, the court is to implement policy. And I believe that there is a danger here of telegraphing perhaps an unfortunate position. I don't think that it is the position of a court to be entering into this policy discussion. And in any event, I am convinced as an attorney that there is no doubt that there are two clear-cut jurisdictions in Trinidad and Tobago which can entertain complaints of sexual harassment. One of them, as has been explained by Ms. Bundu and Ms. Gomez, is in the industrial court. And that is a well-established jurisdiction. There are important pronouncements coming out of the industrial court. We remember the Republic Bank case in the 1980s where sexual harassment in the workplace has been clearly defined and dealt with judicially. So the process in the industrial court, as I am sure Labour has already said and will confirm, is that they are confined to the workplace, they are confined to workers. Perhaps managers may have a difficulty in litigating sexual harassment in that forum. But the basis of the jurisdiction in the industrial court setting, in the labor setting, is that the employer has a responsibility to provide a safe system of work. And if they do not provide a safe system of work in not attending appropriately to a complaint of sexual harassment, they're in breach of that. And the worker can create a grievance. They have to find a union, create a grievance, go through the procedure in the industrial court, the conciliation, the grievance mechanism, and then take it to the industrial court. In the Equal Opportunity Commission, what we do is we receive the complaint, we investigate it. If we don't conciliate, we send it up to the tribunal. Now, our organization mirrors exactly the CARICOM model legislation in that the architecture is the same. You have a commission, you have a tribunal, you can spread your receipt of complaints across 4 areas, not just employment. We can deal with the provision of goods and services, housing, education, training. These are other areas, as Winad mentioned, where you need relief as well. So I want, in concluding, as it were, to endorse the need for specific legislation in Trinidad and Tobago to deal with sexual harassment, to deal with any lingering doubts that any agencies or persons may have as to the existence of this remedy, the well-established existence of this remedy. And what I want to lay in this committee is that there are options. The Equal Opportunity Commission is already deep into work with the Attorney General with an ad hoc committee where we have drafted amendments to our act, which would not introduce any new law, but which would just bring clarity. It would declare that the remedy already exists for the avoidance of doubt, and it would provide some definitions. It would mandate that workplaces should promulgate a code. We would not put the code in a hard document, maybe perhaps an appendix. And what we say is that the remedy should be available in a workplace that has 5 or more employees. So that is one model of legislation which is already in train. It's just one model. Another equally appropriate model would be for there to be a standalone legislation which would confirm and declare that there already exists these jurisdictions, both in the Ministry of Labor and in the Equal Opportunity Commission, and go through with the definitions and so on. So there are options. It is desirable for there to be legislation. What I say is that it would lay to rest any lingering doubts as to whether. Now, in terms of...
Ms. Sivransu?
Yes.
I want to move off this point.
All right, very well, madam.
And I think your point has been well established.
Very well.
I want to indicate, though, that the remit of this committee is to examine legislation, policies that relate to sexual harassment, both regional and local level. We don't have legislation, standalone legislation. But I also want to say that the role of the tribunal as opposed to the commission, I would imagine that those are expressed by the Act, And I am not, if I heard you correctly, and if I understood you correctly, I don't know if it is the role of the tribunal to simply act on a recommendation from the commission. I would imagine that they would do their own submission of evidence and so on and make a determination. But whether that is so or not, the issue that I want to take away from what you would have raised is that there is doubt. Some may be convinced of the applicability of that act to the sexual harassment, and that may have been played out in other jurisdictions. But in our own jurisdiction, it would be the role of the court to decide that. And therefore, it begs the question, and really emphasizes the point then, that we may need, as we are thinking in our country, to move towards specific legislation so that the matter is not open to interpretation, as it clearly is right now, because obviously there are some for, and there may be some views against, as was expressed by the tribunal. So that discussion, I want to thank you for that submission. I want to bring the issue of the worker, the whole definition of worker, and I want to bring the NGOs who are present with us into this discussion to speak about the issue of the worker. We spoke about the unionized worker, we spoke about the ununionized worker. What about those people who work and are not captured in the definition of a worker, and what would be their position with respect to sexual harassment? Can I invite maybe Winard to begin this discussion on what happens with those persons who are not captured by the definition of worker? What happens to them, and what is their role?
Thank you very much, Madam Chair. It's a matter that we addressed to some extent in the joint statement that was submitted to the committee, and our argument there was that, and again, it has to do with the fact that we have broadened the definition of sexual harassment to outside of the workplace and allowing persons who may not be identified as workers in that particular setting to be covered as well, which is why we talk about people who experience sexual harassment who may come to a workplace or an organization, a company, to provide service or to get service, and they are harassed. And so for us, workers, and particularly, and this was a contribution from NUD, the National Union of Domestic Employees, the business about domestic employees not being considered workers is very problematic. And we would like to see that category of worker covered as well in the legislation. And I think that the national policy has attempted to do that. There's also the current situation of migrant workers, particularly from countries that are near to us. And we feel that there needs to be coverage of those persons as well, who may find themselves in domestic situations or commercial situations, and their rights are being eroded. So for us, we want to expand the definition. We want to capture any and all workers who are not currently covered under legislation, and I want to flag particularly domestic workers and migrant workers. And if I may take the opportunity, please, Madam Chair, through you, to find out really if there is a space for comments from the public on the policy that the Ministry of Labour has presented to the Parliament, in which the Minister made a statement, and I guess it's not laid as yet, and therefore there may be space for discussion still. I ask that because, and I'm speaking here now as Winard and not as the collective that submitted the statement to your committee. Internally, Winard has done a review of the policy that the Minister presented in Parliament in March 2019, and we have some comments. So first of all, we want to thank the Ministry for that work. It is really advancing the work that we've been doing for a long time. But we have comments from the definition that the ministry has selected to use in the policy, right through to the role and the responsibilities of the employers, the mandatory implementation of the policy, etc. And we'd be very happy to make submissions to the ministry if there's space for that to be done still. Thank you.
I want to invite some of the other NGOs to weigh in on this, but before I do that, I just want to ask a quick, straight question to the Ministry of Labour. Is there still room for comment?
Madam Chairman, definitely. As we seek to implement the policy, we are welcome to further suggestions and recommendations.
Okay, good. So with that being said, can I ask some of the other NGOs to weigh in on the issue of the coverage of other workers with respect to sexual harassment? Ms. Brown?
Yes. Role of the trade unions. If you look at the policy in under 9 where it talks of action by stakeholders, there's a lot of discussion about the role of the employees. There's nothing there that speaks specifically on the role of the trade unions. Now we know that some trade unions have in fact in their agreements including provisions of sexual harassment that cover what happens in that specific organization. But we think there's a need to expand in 9 where we talk about action of stakeholders for a more definitive role and responsibility for trade unions. It's significant that among the people who are here, we don't have trade unions.
All right. So I think one other wants to comment. Ms. Burgess?
I want to add, in the case of, say, NGOs where we have volunteers, they too would not be recognized as the workers, but they could be harassed. And how do we treat with those people?
And I think we have, just state your name.
Good morning, Madam Chair. Yes, Stephanie Leach Womantra. I'd like to apologize for arriving late this morning, and I didn't have the opportunity to give my oral statement, and I was wondering if I can do so now.
You'll have an opportunity to give a closing, so I want to ask you to just combine it in there when you're going to close,
okay,
so that we could not lose the trend of the discussion as it is now.
No problem.
All right. I think something.
Thank you, Madam Chair. In terms of all the various groups, Ministry of Labour and all represented here, in terms of a definitive definition of sexual harassment, right? I have read in one of the documents here as a sex-based behavior that is unwelcome and offensive to its recipient. Is that the general definition held by all groups, basically? All right. In going forward, we have been hearing a lot about sexual harassment, most times in the workplace, but I just heard Ms. Sweet, mention, and from in reading and so on, it can be in many other different categories, right? But I think from where I sit, there's the notion that it's mainly based on, this sexual interference in the workplace, and most times with boss and subordinate, for want of a better word. Where it is that, and all that has been said and done, why it is today in 2020 that 2019, I'm saying 2020, right? No, in 2019, that there is no one definite legislation, right? I think, we are here in the ministry, but no timeline has been mentioned. Yes, a presentation was made to Cabinet in February 2019. Yes, the minister made a statement. And you mentioned also in your presentation that the National Workplace Policy on Sexual Harassment is being currently finalized for implementation, and it still has to be submitted to Cabinet. What is your timeline in going forward? What is your mandate? What is your focus in terms of when can we say legislation would be forthcoming?
The policy would have been approved by Cabinet. At this point in time, with respect, so I'm going to answer try to put it into perspective of the stages to getting to legislation. So we're actually, there are 4 stages to getting to legislation: policy, legislative drafting, parliamentary stage, and then the implementation stage, that is with respect to legislation. We're at the stage of having had the policy approved. So what we are doing now is we're preparing drafting instructions, which we will utilize in accordance with the Chief Parliamentary Counsel's Department of the Ministry of the Attorney General to finalize the draft legislation for laying in Parliament to get to the parliamentary stage. At this point in time, and given the value of the work of this committee that we're currently here before today, and some of the comments that we have heard from the first hearing of this committee, we thought it wise to wait for today's session and to hear all of the comments so that we would be in a better position to respond and draft appropriately effective legislation to lay in Parliament. So I can't give you a definitive timeline. It is one of our priority matters. Going back historically, this issue of sexual harassment in the workplace would have been subset of basic terms and conditions of work legislation that has been in the drafting for almost 19 years. And because of the magnitude of that piece of legislation and the way that things have been happening in terms of the complaints we've been receiving, a decision was made last year to pull sexual harassment out of that piece of legislation so that we can deal with this more effectively as a standalone issue. And as I said, we don't have a specific date and time, but it is a priority. And as we take the comments and the recommendations from this committee, we will have to go back at the ministry and determine in the implementation of this policy what timeline we would aim for legislation.
Senator Ahi.
Ms. Wundu, in your opening statement, you mentioned the phrase long term, and that had me quite disturbed. You also said that remedies currently available and the union could assist. Are you aware that most of the cases, including the celebrated Republic Bank case, the union represented the harasser? And if you look at a lot of the judgments that are coming out of the court, it is really some harasser who has been fired, and the union has come to say he should not have been fired. So I don't know what comfort one can give a worker when that is the way it's really been playing out in the courts. Now, since around 1991, you had the CARICOM model legislation, a series of legislation. Some people are here who sat at Normandy Hotel for a number of days, and we trashed it up. So we got the Domestic Violence Act. So isn't it fair to assume that there's no sense of urgency? Because Belize came on board in 2000, and we have other people. But isn't it a fact that it is not really a high priority? Because all you need to do is to take the CARICOM legislation, the model legislation that was trashed out by a number of us, and bring it on board. That is what is happening in, the other parts of the Caribbean. So there's no hard maths in that. This is a draft that can be brought to Parliament in short order, if it is that we feel, as a country, that this is important and that many people are suffering in this country because of sexual harassment, the lack of having these laws.
Yes, please.
Thank you. Well, first of all, let me apologize for causing any fear by the use of the word long-term. It was not meant to say that preparing legislation is a long-term goal. Legislation being implemented is the long-term goal. We want to make sure that we have legislation to address the issues that are currently not addressed. With respect to the harassers being the ones represented by unions in cases, recently, within the last couple of months, the High Court would have actually upheld the decision to terminate an employee because under a breach of contract, because the employee would have been harassing someone. So we are seeing a change where it's no longer because a harasser has suffered discrimination, but where persons who have been actually sexually harassed and suffered are finding more of a voice. And what we want to do with this policy is to start raising awareness that you do have a voice, and we are putting things in place in addition to what is already in place. Because we found that to be one of the biggest issues that we've had in terms of persons not feeling empowered enough when they have been victims of sexual harassment. With respect to implementing the CARICOM model legislation, we would have reviewed the CARICOM model legislation as part of our process, and we utilize all of the relevant CARICOM model label legislation, the drafts that they would have done, in the entire labor legislation reform project. One of the issues that we found, for instance, within this piece of legislation, and perhaps because of the age of the legislation, the draft legislation, is that it does not speak to sexual harassment happening via WhatsApp messages or non-verbal. And we need to review it to make sure that, notwithstanding it's good as it is, we have to make sure that it is something that is effective, that is relevant to the society in which we live in, because we have sexual harassment can happen with a video message or a text message. And we need to make sure that the legislation covers the various ways that sexual harassment happens. I cannot answer for anyone else in terms of those who may have come before us, but at the ministry currently, labor legislation reform is high priority. We have gone through, there are only 2 existing pieces of labor legislation that we have not consulted on as yet. Sexual harassment is a priority amongst that. I agree we have a system that needs serious review, and we are doing it to the best of our abilities, and this project is the priority project at the ministry. So we are doing the best that we can with the constraints that we do have.
Taking a comment from Winad.
Yes, thank you very much, Madam Chair. And I really wanted to respond to the question from the member in terms of a definition of sexual harassment. As I said, our internal review, we have comments around the definition. For example, in addition to the use of the word unwelcome in the ministry's definition, we would also want to see in there unwanted. And we're happy for the opportunity to be able to forward our comments to the ministry. But we also looked at the definition presented by the ministry, and we have some strong comments around the business of unreasonable, because we think that there is a potential inside there for us to blame the person who is making the complaint, and we'd like to see that tidied up. In terms of our collective statement that was submitted to your committee, we advanced several recommendations for consideration as definitions, or perhaps to pull several elements of these various definitions so that Trinidad and Tobago has a relevant definition according to the ministry for our times. And so we presented to you the definition used by CEDAW, the University of the West Indies, the definition that it uses as well. And we also looked at the Australian Human Rights Organization to get some guidance from, so that, we'd like to point the committee members to our written submission for examples.
Mr. Perret.
Thank you very much, Madam Chairman. Madam Chairman, I have 3 questions, 1 to the Ministry of Labour and 2 to the NGOs, with your permission. Mrs. Bundu. Morning. First, let me thank everyone for their submissions. It made quite a bit of interesting reading. As an employer myself, I sat with some of my own staff, and we discussed the national workplace policy in some detail as well. I want to just identify
three short paragraphs in the policy document, page 24, page 27, and if I could just quickly read it. Every employer must therefore take steps to develop, implement, and promote a sexual harassment policy that is suitable to the structure of their particular workplace. The other one, all employers will be required to submit an annual report to the Minister of Labour specifying the sexual harassment complaints received during that period, as well as the manner of resolution in each instance. And lastly, all employers shall notify the Minister of Labour and or the Secretary with responsibility for labour of all cases of sexual harassment within 1 month of the date of the report. What I did not find in the policy document was how will those areas be enforced by your organization. I didn't get any enforcement to make sure that that will happen. Is that something that is going to be coming in the legislation coming forward?
Yes. Yes, member. The enforcement aspects, and specifically how it will be enforced, will come within the legislation, and we would have to be guided by the Chief Parliamentary Counsel's office as to what exactly would be most appropriate in the circumstances. But this is just to remind that this is not dissimilar from other provisions within labour legislation, where there's an obligation in statute to report certain things to the minister. And this is very important because we would have recognized that there's an underreporting of sexual harassment. So by putting in this requirement to report, decisions can be done with as much data as possible before us at the ministry.
Do you think in terms of the employer, in terms of punitive actions against the employer, is that something that exists in legislation in other jurisdictions?
Punitive with respect to?
So you have two parties engaged in this dispute with regards to the harassment, and the employer is in the middle of it. The employer ought to take some action, or to take some action preventing it, or something in their policy that should speak to employees against those type of actions. The question I want to get at, will the employer be held in terms of having a punitive action taken against the employer by the state? That is what I want to get. If in other jurisdictions are employers held punitively, whether it be a cost to the parties, whether it be some sort of action against the employer themselves, is that in legislation in other jurisdictions?
We have not, it's not only within other in other jurisdictions, but within our current labour legislation construct, when the employer has certain legislative responsibilities and it's mandated to take certain action and they fail to, the requisite fines would apply. And so one of the most up-to-date pieces of legislation with that style of drafting would be the Occupational Safety and Health Act.
So in that case, just finally on that one, the requirement for employers to have very strong policy documents in their workplace and ensure that employees read and sign on and understand. The message to employers really is that, look, get on board with this document, this policy document. Start rephrasing, relooking at your own internal policies. And would there be a requirement in terms of the size of your companies or your business that will determine whether you are going to enforce having these policy documents? Or is that something currently being looked at?
Certainly in the draft excuse me, amendment to the Equal Opportunity Act that is currently before an ad hoc committee of the Attorney General, what we have proposed is that the obligation would be created in a workplace of 5 persons or more. But the interesting dynamic with respect to the question how the policy relates punitively to the employer is that it's not so much the question of the content of the policy or how well articulated the policy is. Really the issue and the problem is the commitment to management to eradicate and to deal with sexual harassment, because usually the power dynamic is that perhaps it is a superior officer who is preying upon a junior, and no matter how well articulated the protocol is, if it is that the workplace values the manager more than the employee, what usually happens, and that is the experience certainly in Trinidad and Tobago, we have a number of cases right now, what happens is that the employee complains, is managed out because the employee is of less value to the organization. And certainly abroad, what has been found is that what really assists in solving the problem is where the employer is in danger of suffering reputational damage. So that, and sometimes they've gone even overboard, where what is happening is even without due process, managers are being forced out merely because of the allegation, a threat to stop buying the product. So what we have to try to get at, I mean, we have the protocols are beautiful, they're well written, they are all over the place, but the question is, how do they work? And what is the protection? How do you walk through? How dare a person who is suffering from sexual harassment take it into their hands to make a complaint when they are the ones that are going to be on the line? So one of the things that we have to look at is, how do we walk, how do we design a process whereby we walk the complainer with companions and champions through the process? And there is also the big issue of non-disclosure agreements. And so that what happens is employers, large employers, have pools of money, which they have there, to pay off women who have been harassed. And then the women are forced to keep silent, and the harasser continues to harass, and the woman goes away silently and disappears. So it's not so much, we have wonderful policies all over the place, big corporations, massive policies, well-articulated policies, but it's a question of how do you get the employer to commit to eradicating this mischief?
And I'm glad you said that, because I want the second question that I have to the NGOs, and any one of the ladies there can respond. Having heard all the responses so far from both the ministry and the EOC and EOT, and having read, I'm sure you all have read the document itself, are you satisfied that this document is adequately addressing the challenges that are being faced by complainants in these matters? Are you satisfied?
Let's take Womansha first, and then we'll take Ms. Mundu.
Okay, so to respond to your question, and also to Ms. Sweet, what Womansha's position is that there should be a proper development of a whistleblowing procedure, which is currently not included in the policy, which we feel is a critical elaboration for the safe and adequate internal grievance procedure. We recommend that any sexual harassment policy contains a robust grievance procedure, including a provision for anonymous reporting. While we acknowledge that this channel provides certain limitations, since the victim is not identified and the details of the incident cannot be verified, it provides an opportunity for the organization to renew its commitment to training employees and management staff and ensuring the proper dissemination of the workplace policy and the organization's commitment to preventing sexual harassment. While we also acknowledge the provisions of the policy for informal reporting and the role of the Conciliation Unit Advisory Services, we would also recommend that policy encourage the implementation of an employee assistance program to both private and public sectors, whereby mediation between parties is not the only remedy to resolve incidents of sexual harassment, but that victims may be able to access a therapeutic environment and independently decide on the method of their own healing. The current policy provides recommendations for victims' response to harassment, including that victims should directly communicate their discomfort with perpetrators. And while we acknowledge that this approach may be feasible in some instances, it is also important to acknowledge that differential power dynamics in the workplace make this kind of interaction very difficult for many individuals who are experiencing harassment, particularly those who are in a subordinate position, as Ms. Lynette Bransweet pointed out. Further, it is important for a policy that seeks to highlight the particular vulnerabilities of women to sexual harassment, that we acknowledge that subordinated positions in the workplace are not only a result of the individual's position in the organization, but also a result of the designation of their sex itself. So Womantra is of the view that further attention should be paid to these dynamics, which will help to inform the development of victim-focused remedies, including the provision of various channels for reporting, at least one of which anonymously receives complaints, as well as allow for the psycho-support of victims without the perpetrator or the accused perpetrator being apprised of a complaint or their direct involvement in the remedy determined by the victim. Thank you.
And what I want to just, before you go on, Mr. Perry, I want to indicate again that the Ministry of Labour has indicated that there is still room for these recommendations to be followed and to be forwarded to them and taken into consideration. So I want to encourage all of the NGOs again to ensure that their recommendations are sent, and I'm sure you will speak to Ms. Bundun after to find the correct mechanism of sending. And I also want to ask Ms. Bundun in her closing, when we reach to that point, if you can indicate how members of the public who may have been looking on, listening, and would want to give comments, how they can be accommodated as well. So in the closing, maybe we could accommodate that when you give your remarks. Senator.
Madam Chair, before I just issue my last question, I know the other NGOs present. I don't know if they want to just weigh in on my last question in terms of satisfaction on the document.
I just wanted to say that as this is, it's really a framework, but it's incumbent on the employers to really drill down into developing their policies, along the lines.
Madam Chair, on behalf of employers, the Employers Consultative Association, we represent employers. And what we are experiencing right now is that employers are attempting to address complaints of sexual harassment. We have the policy, a draft policy, and we are speaking today about employers implementing, circulating, having employees read, etc., and sign. But the challenge we are seeing now is really understanding, the level of understanding. Literacy, in a number of cases, will be a problem. Because we talk about smaller businesses, we talk today about employers who have more than 5 workers, but even with employers who have more than 5, there is a level of literacy, a challenge with literacy in understanding these policies, both at the level of the employer and the worker. Even in the presence of having a policy, what we are seeing is the difficulty in managing a claim of sexual harassment, not for a lack of willingness, but the sensitivity of the thing, the steps to it. How do you go about engaging the perpetrator versus the complainant and so on? You find employers are doing all sorts of things, which we have to tell them, wrong procedure, wrong methodology, whatever it is. So how do we go about really educating employers, even if we have the policy and the legislation, in dealing with such a sensitive issue as sexual harassment, making sure you do it right, making sure that you don't worsen the situation. And therefore, I see some need, I don't know what channel we will use, to really educate employers as to the practical step-by-step way in approaching issues. Remember, no 2 sexual harassment claims will be the same. And as is general in even dealing with discipline in the workplace, employers have challenges dealing with normal disciplinary matters. This particular issue is going to be much more sensitive. It is already, and will require a lot more sensitization and training and education among employers. And the other level, as I said, the literacy issue is key in this particular issue.
Could I ask the Ministry of Labour? I'll tell you it after, because I wanted to know in terms of what the employers just raised, what is the Ministry of Labour doing to address that? But we will take the NGOs on this issue, and then we'll come to that. So, Ms. Brown, you will.
Yeah. I just want to go back to the issue of the role of the trade unions in this matter, because the policy simply says to the trade unions are responsible for protection of their workers, so go and join a union and leave us alone. We think that there needs to be in the policy, just as there was attention paid to a curious set of people called third-party observers. There's a group here, third-party observers, and a lot of attention was paid to somebody outside of the person who is affected and the employers taking on the responsibility for what is happening in there. We think the policy would be better implemented if there were specific rules and responsibilities of the trade unions. We know that some trade unions have done very good work with the agreements, including provisions for sexual harassment in the agreements. What happens to workers, employees who don't have those kinds of protection from their unions? So we think that's a weakness of the policy as it is, that the workers' responsibility. Although later on there is a whole set of a whole approach of what the workers should do at the bottom on page 30, that they should report, that they should keep records, they should, a lot of things that they are required to do. Now you're already a victim, and now a whole set of responsibilities are put on you as to what you should do to protect yourself if you don't have to go and join the union. And I think if we go back to the human rights approach to this thing, the first person who should be benefiting from this would be the person who is being harassed.
Madam Chair, just last question. This committee had a survey done, a public survey done, and we got a very good response in terms of the public sharing some of their views. And I took note that 80% of the respondents were women out of the total. Mm-hmm. And out of that 80%, about 60 to 65% of them, when asked if they were ever subjected to sexual harassment, if they reported it, and 65% of those respondents said no, for a list of reasons: victimization, fear of loss of job, fear of being able to be promoted, and if they lose their job, the next employer they go to, there is a stigmatization that went along with it. So my final question, and more so to the NGOs here, do you think we, as a society and as a father of three very smart young women, are we driving our young women to excellence? And it's recorded at the SCA, it's recorded at CXC, you're seeing it at the university level, that when they go into the workplace, that because of that drive for excellence from our young women, they are now afraid that if this stumbling block of sexual harassment comes up, it may impede them in their journey going forward. Just as a commentary, do you think it's something that we are forcing our young women today that is causing that, or may there be other factors that are stopping them from wanting to report these instances to deal with it?
I guess it's open to anyone's comment. Swinat?
Yes, thank you very much, Madam Chair. And in response to the member, let me start off by saying continue to provide the protection that you do to your daughters. And that is what the society has to do. And the policy that we are discussing this morning is a step in the right direction. We need to have guidance, we need to have markers put down as a society to demonstrate our collective commitment, really, to taking care of all. So that I don't know that because women may be pursuing excellence, that they may be reluctant to make complaints. What I do know is that we do not provide sufficient protection to women when they do make complaints. And it starts off from the victim blaming, the lack of policy, the lack of legislation, and just a culture that is not supportive, really, of women's rights. And so that's where we have to start. And so this is a really good place to start by having a policy that we are discussing this morning. And like I said, we do have some comments around how that policy can be strengthened, and we feel it is our responsibility to help in strengthening that policy so that we all benefit. But let's encourage the complaining let's ensure that when the complaints are made, and I want to go back to the policy, because in the policy there's reference to a conciliation advisory and advocacy division. And we are hoping that that would be a well-resourced and well-managed division to give really prompt responses and support to people who may come to the ministry. We also think in terms of the policy that the ministry needs to be a little bit, the language in the policy needs to be stronger around the mandatory implementation of training. Because we want to build awareness, we want to call on employers to have and to take on their responsibility. We want to equip them and support them to do that, and we want to ensure that complainants get prompt and just responses when they make a complaint.
Ms. Brown, you want to make a comment? Oh, sorry, your mic is just on. Okay, we'll take your mic. You want to make a short intervention? There is going to be a closing.
Yes, I'll wait.
All right, but I wanted to ask specifically then the Ministry of Labour with respect to the point made on employers and their difficulty in instituting the sexual harassment policies, and so what's the Ministry of Labour's approach to assisting the employers in getting that done?
One of the responsibilities of the ministry, of the government, and in this respect directly the ministry under the policies, to undertake advocacy and public awareness campaigns to address the issues at the workplace. Part of those campaigns would be going out to organizations or workplaces and conducting sensitization sessions. It's something that we do currently with other policies that we have and legislation that we have. So we have no problem continuing to partner with either the ECA and other employers or other organizations in order to bring clarity and assist persons in developing their policies and implementing their policies. And that is why we do have in the policy provision for the establishment of the Conciliation Advisory and Advocacy Division.
Okay, Mr. Ford?
In terms of reporting, right, the Ministry of Labour, in your document to us, you identified that there were 13 cases of sexual harassment cases between 2012 to 2018. But from the discussion and the discourse, does the Ministry of Labour record the cases based on the other categories as mentioned by the Equal Opportunities Commission? Is that factored in here with these 13?
No, the statistics from the Equal Opportunities Commission would be the cases that would have been reported to them and not the cases that would have been reported to us. So we would specifically deal with sexual harassment cases that come to us as trade disputes.
So therefore, putting aside the Ministry of Labour, right, with the statistics, we will have a higher figure.
Yes.
Anybody could share in terms of statistics where we may be at exactly within, let's say, the last 5 years?
Well, let me speak to the statistic with respect to our last reporting period, 2017, where 20% of our complainants brought a complaint in the area of sex discrimination, and of those, 5 included or specifically complained of sexual harassment.
And in terms of the other categories that you identified earlier,
well,
are we tracking those records?
Oh yes, we have in our annual reports we track, and we have by and large the largest area of receipt by us of complaints is in the area of employment. But we also deal with the areas of the provision of goods and services. We also deal with discrimination in the area of access to housing and access to education and training. So in that sense, we already have a broader remit than just employment. And in fact, the CARICOM model includes even other areas. So it is an area in which people think very carefully before they make a complaint. But there are complaints. It is a phenomenon of complaints.
One last question, Madam Chairman. Is sexual harassment the proper term to use for what we are discussing?
Well, absolutely. It's the term of art. It has been around now for 40 years. I mean, why change it? There are many different ways of coming at what exactly constitutes sexual harassment. You have many different models. You have the Australian model. You have models taken from, some people define it as a quid pro quo model where it's exchange of favors. You go on a date and I will promote you. Or harassment in the environment, the creation of a hostile environment where unwelcome comments, a sexualized environment which makes the victim, we don't like so much to use the word victim, but the recipient uncomfortable. So there are many different ways of coming at a definition, many different models around the world. And it is important for us to have a conversation in Trinidad and Tobago as to how we come at the definition, because there are cultural issues here as with everywhere. But I think the essence of it, the nub of it, is that as we are seeing in the United States of America with the former Vice President, Mr. Joe Biden, it is that you must not make the other person uncomfortable. And even if it is that the person complies with your demand, that does not mean that they are not being harassed. They may not have had a choice because they have children to feed, they have to keep their job. So it's not whether they participate in the activity, but what is the power relationship as to whether they felt they had to participate in the activity. And if they don't participate in the activity, then they stand the consequences. They start getting letters. You came to work 5 minutes late. In a month's time, they have a record, and then the next month they are managed out. So,
okay. So I want to go back to the issue now of the workers. And I want to ask specifically, with regard to the policy, how do workers who fall out of the definition, as according to our national labor law, how does the policy meet, how does it reach them? Does it reach them? And if it doesn't, then what do we have to do, or what is the intended action to be able to reach those types of workers?
So the intention is that the policy is to apply to all workers. And it is, you would notice when you examine the definition of workers within the policy as opposed to any of the other legislative definitions of workers, this is a much more comprehensive definition. The intention is also for the policy to apply to situations of domestic work so that we do not have a limit of there must be more than 5 persons in a workplace for it to apply. No, because then we would exclude a lot of the domestic workers and from this protection under this policy, and they are an especially vulnerable group because of some of the issues in terms of awareness and communicating. So one of the main ways that the ministry intends to get out to the vulnerable groups, so the groups that would be more susceptible, we have a lot of experience based on implementing our other pieces of labor legislation, rights-based, especially in terms of maternity protection, and your minimum wages orders. So based on our experiences, we would use that and the information we have from those experiences to craft a targeted implementation plan and awareness program for these sectors and these persons, because we want to ensure effective implementation. It's not just about implementing, but implementing effectively.
So for the benefit of those who are listening now, if you fall into that category, you're a domestic worker, or you work in a very small company, and you're experiencing sexual harassment, what are you to do? What does the policy provide for you to do?
So this question I would ask my colleague, Ms. Gomez, to address, because at the conciliation unit, they have addressed circumstances like this.
There is a union in terms of the National Union for Domestic Employees. It is a very vibrant unit, and that is one of the avenues in terms of collaboration to reach domestic workers, because they would be more than likely employed in the household. And that is why this policy, we made specific reference to the household would be the place of work of the domestic worker. So we have taken it into consideration, and in terms of reaching, we would do public awareness in terms of, going out into the community. But sometimes we can't really reach them, so we would depend heavily on the contacts with Nude especially and other NGOs who would have access to really having these, sometimes they are living persons, because more than likely sometimes they would come into us, but not at the extent in which we want to reach them. So we would have to do some collaborative work with the NGOs and also with Nude in particular to reach them.
But they can also come into the...
They can also come in and lodge the complaint, and that's one of the things we want to do, is have a hotline specifically for issues of sexual harassment. So persons, a dedicated line, so persons can call into that line specifically. So we'll be able to track and monitor, and we will be able to follow up in terms of the numbers that are called, number of persons that are calling, and even able to track in terms of how we address their issues, whether they are satisfied, whether they are pleased with the outcome of the service provided.
Madam, just address the concern, the clear concern that the chair has on this issue. I want to just remind or say that it is possible right now for any person who is experiencing sexual harassment in the areas that I've spoken about, including in the area of employment, to walk off the streets and to come into the Equal Opportunity Commission without the need of the filter of a union or any other organization, and make a direct complaint of sexual harassment, have that complaint investigated. Our law provides that the employer must provide the information that we request them to, on pain of criminal prosecution in the magistrate's court, $1,000 per day for every day where they do not provide the information. They must attend the conciliation. They need not conciliate, but they need not participate meaningfully, but they must attend. And if it is that the conciliation does not work, then the matter is referred with their consent to the tribunal, where the tribunal then acts as a judge and adjudicates on the case. So there is that possibility right now. It happens all the time.
Okay, thank you. I think
Madam
that's
Chair.
very useful information as well.
Madam Chair, now, the reason why we mentioned collaboration, and that is in terms of our treating with domestic workers and also migrant workers, because they would not necessarily step out and come in. So we have to go out to them or reach out to agencies that they would more than likely interact with and would be familiar with. For the domestic, that's why I mentioned Nude, in that is a union set up specifically to treat with household assistance. And they may be more comfortable in having someone speak for them and advocate for them. And they can come into us. By all means, we are open, anybody can just walk off the street and come into us. But in terms of having that person, that comfort in terms of somebody who understands the situation and really is a body to treat with that is why we would want to have this collaborative issue. And also with the migrant workers, they are mentioned. Now, something that we need to clarify, anybody who works in Trinidad and Tobago, they are covered in terms of a worker. So because the person is a migrant worker, whether they're illegal or not, once an employer hires you, you become a worker and you're entitled to protection. But we have been collaborating. We have done it in the past with the Living Water community. So what we do, we go to them because they may not feel comfortable in terms of coming into us, so we go to them. So that is what we have done in the past, and we'll continue to do so. We have reached out to them. So the policy could be shared with them in terms of what are their rights, in terms of if they are sexually harassed or any other work-related issues that we know that they would suffer in the workplace.
Come on, Mantra.
I wanted to speak to the issue of statistics. And just to say that according to the policy, that there were only 16 cases reported to the Ministry of Labour over the past 10 years, and I think Ms. Sieber-Sweet also gave some statistics. And I think the fact that these statistics are so low is what is actually speaking to the gravity of the problem. Because we know for a fact that women and men, but largely women are being abused on a regular basis or sexually harassed on a regular basis. And the fact that the reporting is so low speaks to the urgency for the proper implementation of a policy. The second thing I wanted to say is while I appreciate the existence and the strengthening of external third parties in order to mediate and adjudicate on issues around sexual harassment, I would also like to stress the importance of, as I said before, an employee assistance program so that there is an objective, trained individual within organizations that victims can go to. Because how does a person who is maybe a low-level staff member even going to request time off to leave to go and access Equal Opportunity Commission? So I think that victims need to feel confident that there is somebody within their own organization that they can trust, that is objective and properly trained, who can offer both mediation and other types of psychosocial and therapeutic support.
Madam Chair, that is one of the issues that I think we were concerned about. And in terms of providing solutions, that's why we included psychosocial support, like how employers have EAP on the workplace. There should be some sort of support for workers within the workplace, and we encourage employers to have bodies or NGOs, you know, Families in Action and other such NGOs like that, to treat with supporting the victims and also the persons who would be the perpetrators. They may need some sort of help as well on the job based on the severity or the type of issue that would occur.
And I think it's important to mention at this stage something we brought up in the last meeting where we spoke about the underreporting and the need for some sort of documentation to understand the real position. We would have done a survey, the committee would have done a survey and gotten certain responses. But the fact that we don't have actual data and no agency has undertaken to actually get the statistics, we may understand, okay, there are more things happening than we know, but the actual baseline position, at least at this point, is not something that is available to anyone. And so we are doing the policy and moving towards legislation on the basis that we know this is a problem, but the extent of the problem is not known in Trinidad and Tobago, and there are different reasons for that, but it is something that we would have suggested on the last occasion is important to at least have a baseline figure to understand the magnitude that of the problem we are dealing with. At this time, I would like to invite Senator Ahi to pose our last question of the day.
Now, I've heard talk about CEDAW and CEDAW organizations, and I find that we go a lot to the convention, which is worldwide, and we do not mention at all our own convention in this part of the world, which deals directly with violence. What is the ministry doing in terms of educating people that we do have the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women? Because you spoke a lot about advocacy and public education, and before you go out there with your public education and your advocacy, you have to be sure that people are properly trained, that people are well-resourced because they have the necessary information, and people are taught that sexual harassment is on a continuum of violence against women. We have a television station. We have a number of radio stations. There are a number of women in these television stations and radio stations. And we need to use the resources that we have. There are many resources that we have for free. And we need to use them in public education campaigns. So I would like the ministry to focus, ministry and other organizations to focus on using what we have, because sometimes we think things are insurmountable, and really there are lots of things that you can get for free. all right? So that use what we have and be, I'm sure you want to say that you want to encourage to build people. Before we build the country, we have to build the people who are going to be in the country. Because we just can't have the, you know, all the roads and all the infrastructure and our people are not being built, because what's going to happen later on. So I would urge all of you to concentrate on educating yourselves so that you can pass on the information to the people who you want to help. And be very, very careful about how you operate in terms of the conciliation because of the power differential. When we talk in ADR, is not just mediation. Think carefully about using what has been tried and tested and has been tried and tested all over the world, the restorative practices. It's working with domestic violence all over. So see what's happening in Europe and the United States and the UK, and try to bring that in. So there's a lot we can do, and I'm sure that the minister will assist you. All the ministers involved, including the Minister of Labour. She was very proud of her policy, you know. She came and she presented it and so on, and we're happy for it as a start.
Just before I take a moment, I want to just bring, as we close, the Office of the Prime Minister into this discussion with respect to the sensitization and the awareness. P.S. Johnson, is the Office of the Prime Minister involved in this sensitization process with respect to sexual harassment? And so, I mean, it cross-cuts. Yes, it's a labor issue, but it's also a gender issue. And I'm wondering if there's any collaboration happening or planned, or that you can see being projected, so that you all can also put out the information and speak the channels. Because, you know, sometimes when you to make something really sink in, it has to come from all different directions. So I'm just wondering, what is your role in terms of this area?
Madam Chair, we have been in contact, and we will continue to be in contact with the Ministry of Labour on this policy. This policy is an urgent and important policy measure to support the national policy on gender and development. It has been identified as necessary since we started to craft the national policy on gender and development. The policy measure is led by the Ministry of Labour, and that's clearly outlined in the area on labour in the national gender policy. There's a lot of things that the ministry has to do to treat with this, and we are committed to meeting with them. I think we were the first ministry to meet with them when we started to look at this national policy on sexual harassment. We know that there are some things that we need to do in terms of sensitization. So once we have a policy, it's clearly set up, we would do our part to ensure that we build that awareness in the same way that we are trying to ensure that the national policy on gender development is brought to the knowledge of all citizens of Trinidad and Tobago. Yes, we will continue to collaborate with the Ministry of Labour. We know that the policy, just like any other policy, would affect men and women differently. And so we need to start talking to them, not only about monitoring the policy to ensure that the gender lens is applied to to determine how it impacts men and women, and treat with the equity issues, identify those differences that will promote a more equal policy in terms of the status of both men and women. We know that there are some things we need to discuss with the Ministry of Labour in terms of collecting the data to see how the policy is being implemented, what are the impacts, because we have to report on this measure first, that we have a national policy, and then how it's impacting our men and women as it relates to employment. We have to report nationally, we have to report regionally, and we have to report internationally, on this measure.
And while we're discussing that, I know the Ministry of Gender does interventions with children as well, because I feel strongly that this is a man and woman issue, but it's more of a cultural issue. If we think about it very deeply, it's how we treat each other. And I'm wondering if, in terms of that awareness program, if any thought is given to how we present this, not just to men and women, but to boys and girls. And I don't know if you have any thoughts on that.
Yes, we do. In fact, we have been trying to incorporate it into what we call our foundations program that we hope to roll out this month to our children, boys and girls between 12 and 25. And this is being done through several organizations. It's a UN-based program which looks at all these issues relating to men and to those gender issues relating to men and women, and sexual harassment is in fact one of the things that we look at in that program.
Okay, last comment from Amandra.
Thank you, Madam Chair. I just wanted to respond to Member Ahi's comment about regional mechanisms. In preparation of our coalition statement, it was quite interesting to note that the only specific mention of sexual harassment within the Montevideo Consensus was around specifically women parliamentarians and women in public office. So I thought that that might interest you. And it's noted that sexual harassment of women in public office and parliamentarians is a significant barrier to their advancement. And I think its particular mention in this document is important because it obviously speaks to a regional problem. So it's something that the Ministry of Labour may consider for its inclusion. I also wanted to comment on, Madam Chair, your language around this being a man and woman issue, because I actually wanted to commend the Ministry of Labour for acknowledging that sexual harassment can happen between, people of the same sex, men and men, women and women, as well as women to men. I think that the policy is very gender aware and has not taken the approach of being gender blind. So I just wanted to commend them for that.
No, I'm sorry. When I said man and woman, I meant adult as opposed to child.
Okay.
Right? Not, not that way. So I want to thank everyone for their contributions to today's session. And I would like to invite everyone to now make brief closing remarks. Again, we will start with the Permanent Secretary of the Office of the Prime Minister, Gender and Child Affairs, and come to my right, to your left.
Madam Chair, I would not offer closing. I think I just closed with what I've said. Thank you.
Madam Chair, there's no doubt that this issue of sexual harassment is a workplace issue. But equally, and perhaps even more so, it is a rights issue and a human rights issue and a gender issue, and it does not only occur in the workplace. On the question of the allocation of the resources of the nation, I just wanted to remind us that the Equal Opportunity Commission is an independent body that is paid for by the taxpayer, and it already exactly mirrors the architecture of the Model CARICOM bill in the sense of the creation of an establishment of trained investigators, attorneys, conciliators, and the whole apparatus of dealing with this kind of complaint. And so I just wanted the government to bear that in mind in terms of how we move forward in terms of the legislation. And I commend the Joint Select Committee for taking this issue on, and I am very happy that it is achieving the kind of priority that it has always deserved, and absolutely to commend the Ministry of Labour for picking this up and running with it. It was in 2017 that the Equal Opportunity Commission took the lead to create the first policy and guidelines that we published. And it was very quickly taken up by gender and then absolutely embraced by Labour. And this is where we are today. So that those are very happy developments for Trinidad and Tobago.
Okay, thank you.
Thank you. From what I've gathered, we are really in the process of creating some kind of legislative instrument. I think really there's a need. In fact, I think we're a bit late. These instruments have existed throughout countries, Australia, the UK, Malaysia, other countries. And we are not really seeking to invent or reinvent the wheel. We can take a lot of from what applies now in terms of these legislative instruments. What we need to really ensure, though, is that we don't have a disconnect. Because I'm hearing the Commission submitted amendments to the Act that is before an ad hoc committee. And then I understand the Ministry of Labour is now piloting and pioneering legislative instruments in relation to that. We need to ensure that we have a connect between these, because aside from the various legislative instruments, we also need to look at enforcement bodies. Who exactly is going to enforce the relevant legislation? Who's going to ensure that these policies, that we are able to penalize, for example, employers who breach the relevant legislation and these kind of things. So that I think we really need to have a proper connect between the various bodies to ensure that we're able to take these policies forward. Thank you.
Ms. Bundun.
Thank you very much, Madam Chairman, and members of the committee and colleagues on this side of the table. At the Ministry of Labour, we remain steadfast in the view that sexual harassment is a violation of fundamental human rights. Labour rights are human rights, and we take our responsibility seriously in this regard in ensuring protection. What I would like to take this opportunity to do also is to advise on contact information for the Ministry, so that any comments, suggestions, or further recommendations can be submitted to the email conciliation.mol@gov.tt. So I'll spell it out now. conciliation.mol@gov.tt. In addition, the Ministry of Labour has a very vibrant Facebook page, and we are pretty responsive on that Facebook page. So you can also send a message via the Facebook page. And I would like to highlight that the Ministry of Labour, in recognizing that labour rights are human rights, is not only guided by the relevant ILO conventions, and there is one coming on violence and harassment on the workplace, but we are also guided by the relevant international human rights conventions, whether they be specifically with respect to gender or human rights and civil and political rights or economic, social and cultural rights. And in addition, we do have campaigns where we speak to children, because we recognize the need to build culture, a culture change. We have currently the Speak Up campaign for boys and girls, and we also have a child labor art competition that we use to sensitize our children. They are the ones who are the future workers and employers in terms of what are good labor practices and good practices overall at the workplace. So thank you again for this opportunity, and we look forward to further comments and suggestions.
Thank you so much. Ms. Finger.
Thank you, Madam Chair. I just wanted to continue from the Equal Opportunity Tribunal, the comment made. Hearing all the different bodies speak here today, clearly there is need for some synergies. And I really believe that we talk about opportunities through OSHA, through the Ministry of Labour, through the EOC, and even the Office of the Prime Minister. There are initiatives being undertaken. Different arms are doing different pieces of legislation, amending legislation, etc. And hearing all of this today, I think that there must be that synergy. The employee who is the complainant needs to be very clear as to where is the best place to go to have the matter addressed. What we do know is that based on current legislation, where there's, through the Ministry of Labour, the employee must go through with a union. A lot of these employees will not be union members. Through the Equal Opportunity Tribunal, there'll be need for an attorney, if I'm correct. And therefore, you would find it might be always almost outside of the reach of some of the complainants. So these things must be addressed for the...
Are you saying no? I don't want to make sure.
It is a yes, is it?
No, the complaint must be made to the commission. And you do not need an attorney for that. Okay. If it is not conciliated and you want to take it to the tribunal, which is the court, you may or may not choose to have an attorney.
All right. Yes. Because your point is very important.
Yes. Because there's matters do reach the stage where the employees will require, both at the level of the industrial court sometimes, even though there's a union, or even at the tribunal. So these things must be known, because we are aware of employees who have been stymied in their efforts because of these legal requirements, and were unable to have the sort of satisfaction that they wanted, or even to take the matter. In fact, some have been aborted because they have not been able to go the full course of arbitration. So all of these things, I believe, must be addressed, and it must be made as simply and as cost-effective and as easily available for those who are really in need of having their matter addressed.
Thank you so much, Singa. Ms. Burgess.
Thank you, Madam Chair. And I want to thank the Ministry of Labour and the other agencies that we have reached this far in our discussions. I look forward to the sensitization, and I think that will give a sense of relief, if done well, to Member Parry. His concern of people who have reached a certain level and are not able to have their voices heard. So, I mean, when in the days when we started to talk about rape and incest, there was no word for it. We are now getting to hear about sexual harassment, and people must be given the strength and the confidence that they can report it. I also look forward to your handling of volunteers for our sector. Yes, so that's it. Thank you.
Thank you, Mrs. Brown.
Thank you very much, Madam Chairman. You know, laws are good. They're mostly good for lawyers. If we could concentrate on a goal of creating an environment which is free of violence and abuse, and that would include sexual harassment, then we can clearly determine what is the pathway to that. And so far as we are concerned, there are 3 issues on that pathway. The first one, of course, is awareness. The second one is appropriate mechanism for dealing with the issues that arrive. And the last one is appropriate sanctions that people will know will come out of a certain level of behavior. And those are the things we want to see coming out of this policy: awareness, appropriate mechanisms, and sanctions for people who are encouraging or facilitating an environment of violence and abuse of people.
Thank you so much. The representative from Omandra.
Thank you, Madam Chair. I would just like to close by again commending the Ministry of Labour for what I consider to be a very progressive policy, particularly in relation to its inclusion around provisions for sexual orientation, including that questions around an individual's sexual orientation can be considered sexual harassment, as well as derogatory language. And we see that this is a very clear departure from other types of legislation that specifically excluded these groups who we know are particularly vulnerable. That is not to say that we did not take issue with some of the language used in the policy, as Winard has already expressed, and Womansha looks forward to the opportunity to providing comments around that specific language. Thank you.
Thank you. And last, Womansha, Winard.
Thank you very much, Madam Chair. First of all, congratulations and thank you to you and your committee for taking this on. And our thanks to the Ministry of Labour for leading the country on a path to us really taking on frontally what is a women's human rights issue. And so we welcome the opportunity to work with the ministry to strengthen this policy for the benefit of all. We hope that key to our work will be an acceptance that sexual harassment is really about the unwelcomed and unwanted sexual nature of the behavior. Victims often do not know how to build a case because the victim does not know what evidence to collect, when or how, but also evidence may be considered unreliable by the investigator. An additional challenge is the willingness on the part of witnesses who may fear covert intimidation or open hostility by the employers. And therefore, we want to suggest that the specific types of harassment directed at gay, effeminate, gender nonconforming men also attract some attention in this policy by the Ministry of Labor. And finally, to say that it is important for us to support bystanders in an efficient and practical way so that we can address some of the concerns that you raised, particularly around the issue of underreporting. Thank you very much for the opportunity.
Thank you so much. I'd like to take this opportunity to quickly summarize some of the main points that would have been discussed by us today. The policy on sexual harassment is available to the public, still to be laid in Parliament. The policy is available on the Ministry of Labor's website, and the public is advised to download and to read it. It contains guidelines for both employers and employees. It makes it mandatory for employers to implement sexual harassment policies and/or procedures, but there is no enforcement method inherent in the policy, and this must come through legislation. Unionized workers can go through their unions to address sexual harassment. Workers who are not unionized can get advice from the Ministry of Labor on how to get redress, and also the Equal Opportunities Commission is available. And workers who fall out of the definition of workers, including domestic workers, can also visit these areas to be able to get advice on how to proceed. There has been a concern raised by the Equal Opportunities Tribunal regarding the use of the Equal Opportunity Act in addressing sexual harassment concerns, and it requires careful consideration, and it also underscores the need for standalone sexual harassment legislation, which will be unambiguous in the way it addresses issues of sexual harassment and provides redress. NGOs who wish to make recommendations for improvement or adjustment to the National Workplace Policy on Sexual Harassment in Trinidad and Tobago still have that opportunity to do so. In fact, the general public does have that opportunity. A number of issues have been raised regarding the fundamental definition of sexual harassment, psychological treatment for both the harassers and the victim, whistleblowing protection in the context of sexual harassment, and the roles and responsibilities of trade unions, among other issues. The stages of law development include policy approval, the legislation drafting, the parliamentary debate and passing, and then implementation. At this point, the Ministry of Labor is at the stage of legislation drafting, and so we look forward to the other stages rolling out as we go along on this road towards having sexual harassment legislation enacted in Trinidad and Tobago. In drafting this legislation, the CARICOM model is being reviewed by the Ministry of Labor so that it can be made more relevant to our current situation and the different permutations of sexual harassment that are present in our society. There's also the issue we discussed about the employers who are making attempts to introduce sexual harassment policies, but facing challenges with respect to literacy, understanding of the different policies, and the process. And so education is a very, very key aspect to ensure that we have successful, widespread sexual harassment policies and procedures enacted around the country. In that regard, the Ministry of Labor is willing to partner with the ECA and other agencies and workplaces and employers to address the issue of capacity, so that we ensure that employers understand exactly how they institute these very important sexual harassment policies and procedures. And in the terms of awareness, which is also a very important issue, the Ministry of Labor is in discussion and partnering with other agencies and ministries. The Ministry of Office of the Prime Minister, Gender and Child Affairs, is also very willing to be involved in bringing this sexual harassment issue to all levels, including our children, so that we have a culture shift in terms of how we treat each other. In terms of the domestic employees, the concern was raised by the NGOs in terms of widening that definition. It has been so in the policy, and so we look forward to that being covered in the legislation so that all classes of labor regardless of whether it's domestic labor or migrant labor, they can also have redress. And so, in conclusion, to the workers, people who are experiencing or may be experiencing sexual harassment, I just want to emphasize that advice is available from the Ministry of Labor Conciliation Unit, from the Equal Opportunities Commission, and also through the trade unions and through the NGOs. Some of them are represented here. You can get advice as to how to seek redress. However, just with the caveat that at this point, to go further into legislative matters, you may need an attorney, and that advice will also be given to you as you address the issue of sexual harassment. So we are hoping that those who would have looked on, would have listened, would now have a better understanding of where we are in terms of our sexual harassment policy, what we are looking forward to with respect to legislation, some of the challenges that are inherent in dealing with these issues, and most importantly, that we will be, this will be followed by the systems put in place to make awareness more accessible to the public so that they know what their rights are. So we empower our workers, empower our employers, and look forward to the addressing of this most important issue of sexual harassment within our country of Trinidad and Tobago. I thank you, the viewers and the listeners. I thank you, the officials who have spent, some of you, come 2 times with us. Those of you who came for the first time, we thank you on this issue. And I thank the members of the committee and the secretariat, and now declare this meeting suspended, adjourned. Thank you.